is 10:01, and we are going to go ahead and get started. So welcome, everyone. Happy holidays to your families and you, and welcome to Elville and Associates and the law offices of Gary Greenwald's quarterly client care program webinar. We're pleased to have you here today. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating this morning's event. So you being here today, as always, reflects your strong commitment to your planning and the continuing updating and maintenance of your plan in which you've invested so much time and effort. And as always, the mission of the firm's client care programs is to provide you with the comfort and assurance that your plans will work no matter how your goals and situations may change, and to ensure planning remains consistent with changes in the law. Our firms are the only two in Maryland to have the client care programs accredited through the Client Care Academy in Boston. So they're very comprehensive programs, and we encourage you to take advantage of all the benefits that are offered through the programs. As for today, we have much to cover. We have Stephen Elville and Gary Greenwald ready to share a great deal of education and knowledge with you this morning, and they've worked very hard to put together a comprehensive program for you. Steve and Gary are always available to be resources to you at any time, as you know. You have the opportunity to pose questions throughout using the questions panel on your screen, and we'll address your questions during appropriate pauses in the presentation. Also, we sent 2 checklists by email to you yesterday. We will be referencing during the presentation, so you may want to print those one-page documents out if you haven't done so already. If for some reason you didn't receive those documents, please let me know. And if you'd like, I can work to send those out as quickly as possible to you. Also, we're pleased to announce that we have some door prizes in the form of concert tickets to give away from some fine organizations that we have relationships with, including the Annapolis Symphony Orchestra, Bach in Baltimore, and the Columbia Orchestra. Lastly, before we get started, I'd like to announce our next CCP event is penciled in for Saturday, March 12th, scheduled at Anne Arundel Community College, and we look forward to seeing everyone then, if not before. So Steve, to start us off, I will turn it over to your hands.
Thank you very much, Jeff, and good morning, everyone. And good morning, Jeff and Gary. Good morning, all of our guests and also CCP members, and happy holidays to everyone. We have a lot to cover. That's why our opening remarks here are going to be very short. And I'm also going to ask Gary here in a second if he has any opening comments, but I'll just start by saying, wishing everyone a lovely holiday season. Hope you had a wonderful Thanksgiving. And Jeff, by the way, Gary says my background here is possibly distracting. So if you want to come in and change it, that's fine. And otherwise, if you don't think it's too distracting, we'll just leave it. But back to our introductions here. Want to make sure that you're aware that our next event will be in March. And it's hard to believe it's been this long since we've been together already. So looking forward to March, and hopefully that will be an in-person event, but we don't know. We want you to use your benefits. So I want to encourage you on behalf of Gary and I want to encourage you to use your CCP benefits for updates, for just general use of your hours of time that you are paying for as part of your membership, for us to provide suggestions to you, for you to get a photo done of yourself or your family, or a video that very few of you are taking advantage of, but also to use us as a referral hub. You know, if you have questions, and many of you do send those kinds of questions to us and ask for referrals to financial advisors and CPAs, and forming an advisory team, and you know, you maybe have an issue that has nothing to do with estates and trusts and you need a referral. So we're happy to do that for you, and we're here to do that. And today, like Jeff said, we're going to answer questions as we go along. So if you have questions, feel free to ask them. Jeff is an expert moderator, as you know, and especially on this virtual format. So hopefully we'll see each other again soon in person. And lastly, Jeff has these wonderful prizes to give away today. And I just want to say, to my knowledge, there's been no Russian interference here, and Jeff is going to be able to very fairly choose the winners. There's not going to be any interference, and Jeff's got a methodology, and it's all going to be on the up and up. So we're looking forward to giving away those prizes. Go ahead, Jeff.
Yes, they've already been chosen through a random generator, Steve, so we're all set.
We're all set there. No outside interference. Very good. And Gary, do you have any comments before we start?
No, other than to say that it's been a long year and a half since this coronavirus began. And I'm looking forward to finally being able to get together in person in March at our next event. Although I guess we need to still keep track of the news just to make sure that nothing happens between now and then that causes us to decide to do it virtually, because you never know what's going to happen. And just to add to the comments about how the prizes were chosen, there are no allowable recounts, correct?
That is correct. No recounts. Thank you, Gary. All right. And Jeff's coming in here to adjust my background so it's not distracting. So again, welcome, and we appreciate your commitment, even for these virtual events that I know are not the best. And we're going to try to do our very best here to make it worth your while here this morning. So I'm sharing my screen now, and you should be able to see the presentation, and we're going to get started. And before we get started, remember, this is a lot of information. I spoke to one CCP member yesterday who said, my goodness, Steve, this is a lot of information. I promise we're going to get through most of it as methodically as we can. The tax slides and the tax strategy examples, those particular slides, we're not going to go through each and every one of those. So that will take off some of the pressure, but we want you to have that information because a lot of it is still relevant. Even though we're going to see that there's a lot of hurry up and wait when it comes to the tax issues today. So we're just going to bring you up to date and then tell you where we are and where we think we're headed. All right, so with that said, I'm going to get started. And again, thank you for being here. All right. Now, as I advance my slides here, and Jeff, I'm just going to make sure that my slides are advancing. Here we go. An overview of today's presentation. We're going to revisit back for what we talked about back in March. We're going to revisit the COVID-19 planning considerations. That is still an issue, as many of you know. So we are not completely out of COVID. We don't know where we are really overall. We're going to go over those planning considerations. We're going to go through a very brief exercise of funding and alignment. We're going to kind of revisit that from back in March, because we want to make sure that for all new people that may have never attended CCP and for guests that they understand the funding and alignment concept. And then many of you had asked about motivating adult children to start the planning process. So that's why we chose that today. I'm going to go through that, give you some concepts and ways of motivating adult children, but not only adult children, meaning children biologically of yours, but also any young person that you may know who needs to do planning. So we're going to talk about that. Many of you have specific questions about what happens when one spouse passes away. So we're going to talk about that in detail. We're going to go through the end of year 2021 estate tax and planning update. And finally, Gary's going to finish today with the legislative update, the Maryland and legislative update. And of course, we're going to take questions and answers as we go along. All right, so I hope you have a pen and pencil, and here we go. So as we discussed last March, we're pretty much the same place. Hopefully we're a lot safer in many ways, but the planning considerations for COVID-19 still remain the same. We want to address issues with elderly parents or elderly relatives. We want to address issues with the opposite end of the spectrum, college-age children. We know that college-age children and others, nieces and nephews, grandchildren, they're subject to the effects of COVID. So we want to make sure they have HIPAA waivers and powers of attorney, even if they're simple documents. Get something in place as they go away to school or they're coming home for the holidays. We want to address adult child issues. Again, a lot of this is going to be covered in the how to motivate children to do planning section. So I won't spend a lot of time of it here. Our advanced medical directives, we want to review those in more detail. And I'm going to preaching to the choir here to many of you. We've already got agents. Many of you are on top of this all the time. But we want to make sure that our agents are aware that they've been nominated, okay? And once we are making them aware and not just including them, And most of you are good on this. Most of you not only have nominated your agents, but you've brought them into family meetings and so forth. So just want to make sure that you're thinking in terms of letting your agents know they've been nominated and when their power goes into effect. All right, now those are very, very fundamental. But let's get into more specifics now. Have your religious considerations, if any, been considered? Have your final arrangements totally been considered? Okay. Now remember, the age of COVID, we're feeling good right now compared to where we were, right? But what if we go back to that dark place that we were? That's what I want you to be thinking about. Do the documents specifically address intubation? Okay, so we want to talk about that. Many of you have not really addressed this issue. What we're going to do here at Elville, and Gary will probably do the same thing, I'll let him speak to that, is during your CCP updates, we're just going to automatically start addressing these issues with you proactively as if these should be standard provisions going forward. So again, you don't have to have these in your documents if you don't want to, but on the updates, we're going to act as if these are standard provisions that should be included, and we're going to kind of test you on these issues. Do your documents specifically authorize experimental treatments or not? So that's something for you to continue to consider. Do your documents automatically allow for or mention electronic communication, Skype, FaceTime, Zoom, Microsoft Teams, and so forth? Have you expressly authorized that your fiduciaries are authorized to facilitate a device for communication purposes? So remember what happened back in the dark days of COVID-19, and hopefully we're not going to experience that again. People, and some of you on this call, God forbid, have experienced relatives and loved ones who have died in facilities or been very sick during the dark days of COVID, and there was no good means of communication. And just a horrible experience for those of you who have experienced this. So we want to make sure there is some kind of possibility of communication, that there are devices available, and that these are actually mentioned. Does your document specifically include a clause talking to doctors and nurses, basically saying to them that they are held harmless for relying on these communications? Because remember, many people could not communicate well or at all, or get medical records during the dark days of COVID. Now, on the financial powers of attorney, we want to review agents like we always do, keep the agents updated, make sure they know they've been nominated, that they're aware of their duties, whether their power is immediate or not. And do we want to have more flexible powers, even above and beyond a lot of the flexible powers we normally use? For example, can your agent amend your revocable trust or change beneficiary designations? Now, do your documents specifically address the funding needs? Funding of the needs and requests of your healthcare agent. So what about that financial power of attorney? Does it talk about specifically authorizing funding that your healthcare agent may say is needed? Now, many of these things will hopefully happen as a matter of course, but we want to make sure. Do your documents address, again, electronic communications in the financial power of attorney? We talked about that being in the advanced directive, but also in the financial power of attorney. And of course, the same issues. Do we want to make sure, that the facility knows they are being held harmless? Now, I'm going through these rather quickly because we talked about these back in March, but I want you to use this as a tool. Now we're talking about advanced flexibility concepts. Most of you in the CCP have revocable trusts, but there are some of you that may not. So just remember, in my view, and Gary can comment on this at any time, revocable trusts are probably better than wills during COVID-19. They provide more flexibility, and we're avoiding the probate courts. It has enhanced incapacity management. You can design whether you want a disability panel or a springing power or an immediate power. Provide express powers for trust protectors to remove you, the grantor, under the COVID-19 circumstances. So why would we put a clause in there like that? Well, what if you are not well? And many times documents will say that the trust protector cannot remove the grantor. So we want to be thinking about these advanced concepts. I'm not saying they're right for everyone, but we want to think about them. and other express trust protector powers. Now, here at Elville, we are still working on the possibility of having very solid, consistent diagrams for our clients and our CCP members. Believe it or not, is one of the most challenging things in estate planning, in the estate planning world, is to have quality diagrams. I don't know why that's the case, but we are continuing to work with this. And I think one of the things that we want to provide eventually to all of our CCP members are quality diagrams, so that during a crisis like COVID-19, there are very, very clear paths for your fiduciaries to follow when they're looking at your estate plan and providing diagrams and providing specific authorizations to advisory team members. All right. The last slide we're going to talk about COVID-19, unless Gary has further comments, is during COVID-19 and the dark days of COVID-19, we were authorized by the governor to be able to do wonderful things. Thank goodness, because in many states, this was not allowed. Remote notarization and remote witnessing and remote document execution. Well, those things now are more limited in the sense that we cannot do that for revocable trusts right now. The governor's order allowing that expired in August of 2021. So we're in this gap time where we're not able to do that, and hopefully new laws will be passed allowing that. But there is a new law that went into effect. Gary's going to talk about it in the legislative update that allows for the electronic witnessing and notarization of wills, powers of attorney, and advance directives. So this is a fairly new thing that we're trying to get our minds around, but Gary's going to describe that in further detail. Gary, before I move on to the next subject, any further comments about COVID-19?
No, I do not, other than I will say that I truly have not enjoyed it.
Yes, I agree with you. All right,
Steve?
thanks, Gary. Go ahead, Jeff.
Steve, before we move on, can you click on the upper left-hand corner where it says play from current slide?
Oh,
That
yes,
will
I'm sorry, Jeff.
enable you to have your
Yeah.
screen in full
I
screen.
apologize.
Thank you.
Yes, I should have done that.
No
So
problem.
hopefully everyone was able to see that.
Thank you. Yep.
All right. Now we're going to switch to a very quick funding and alignment exercise. Back in March, we talked about this, and our funding coordinator here at Elville Associates, Mary Gay Kramer, was actually here. Mary's not here today, but I just want to make sure, especially since we don't have a guest speaker like Mary today, that we go through this very simple process. So most of you are right on top of this. You are funding and aligning your assets for estate planning purposes, whether you have a will or a trust. So the asset alignment process is critical. In my view, there are two steps in all estate planning: the design of the will or the design of the trust. And then the second part is the alignment of assets. Even with wills, we have to align assets with beneficiary designations. But with a revocable trust, we want to take that second step, and we want to make sure that all non-retirement assets are in the revocable trust, and that business interests are properly aligned, and retirement plan assets, IRAs, 401ks, 403bs, 457 plans are properly beneficiary designated, along with life insurance, which we're going to talk about more later. So the asset alignment process is absolutely critical. It begins, in my view, with the completion of the estate planning questionnaire. That estate planning questionnaire is one of the most fundamentally important things in estate planning, because that gives us the information we need to feed back to you, the client, in the form of completed documents and a comprehensive funding and alignment of assets. Preparation of a spreadsheet, and many of you are very, very good about maintaining your asset spreadsheets. Once the documents are executed, that's when the second step starts. So that first step is the design of the documents. The second step is the funding and alignment, however you want to refer to that. And again, all of this, for most of you who have revocable trusts, is for probate avoidance. Now, there are many other types of plans. There are special needs plans. There are elder law type plans. There are asset protection plans. All of those plans have some form of asset alignment. But this particular concept is the same for the basic alignment with wills or trusts, or for advanced planning, asset protection, irrevocable life insurance trusts, which we're going to talk about later, The concept is still the same. We have two steps, basically, if you want to think of it in very simple terms, two steps in the funding process or in the planning process: design and then funding and alignment. All right, and here we're mentioning again, Mary Gay Kramer is our funding and alignment coordinator. Of course, Gary and his assistant Polly and his staff do funding and alignment for the Greenwald clients. And of course, the client care program, thank you for being members. Thank you for your support. Thank you for your commitment. Gary and I together have one of the only law firms, Gary's firm separately and Elville and Associates separately, are two, I should say, of the only law firms in Maryland that we know of that are in the Client Care Academy accredited program out of Boston, and only 75 of these firms in the country. So Gary and I are very proud to have a maintenance and updating program like the Client Care program.
Steve, if I can just
Please, Gary.
add, I think between our two firms, we have about 130 families enrolled, don't we?
Yes, I think that's about right. I'd have to see the exact number, but we're very proud of that. And, we believe that this fundamental idea of revisiting planning on a consistent basis, and you being a willing participant and allowing us to encourage you to continue to update your plans, that is what's going to ensure that your plan actually works. So that's why Gary and I encourage you to please use your benefits. It's a very, very busy world. It's a busy life. It's getting busier and more complicated, it seems. But some things never change, and that is the consistency that's needed to really perfect your estate planning over time. And I take my hat off to those of you who really use your benefits and take the program seriously. So thank you. All right. Now, let's just take a deep breath. Those were the first two preliminary subjects we wanted to cover today. And now I'm going to get into the more meaty subjects. And these are the programs or the presentations that many of you had asked for. So let's get into the motivating adult children to start the planning process portion of our presentation. And Gary's going to come in and make comments as he sees fit. So here we go. And as we put together this material, you're going to see these initial bullet points. And as I thought about how do I best share our best advice about how to motivate children, adult children, I thought about an order of priority. So let's just go through these. And in my opinion, and Gary can comment, these are the kind of the priority issues for young families, for young adult children who have families and need to do planning. And those of you who are frustrated, maybe you can't get your children to engage in planning. You're working very hard to convince them to do planning. Hopefully, you're going to have one or two or three trigger points here that will help you motivate them to do planning. So in the order of priority, in my view, what is important to young adult children with young children, meaning minor children? Addressing guardianship issues of minor children. This is by far the number one thing. Remember that according to statistics that I've read most recently, about 80% of people age 44 and under, 80% have no will. So that means 80% of adults have no will that are under age 44, regardless of whether they have children or not. So for adult children who have minor children, this issue of guardianship, addressing the guardianship in the will, the guardianship of minors, that is the number one motivator. So if you want to motivate your adult children, that is the motivator. That's the primary thing. Addressing the planning issues for minor children. So not only guardianship, but addressing how their shares, the shares of minor children, will be held in trust. Addressing planning issues for children or other loved one with disabilities. Now, normally this takes care of itself. So we're going to go through slides of each of these. So I'll just go down the bullet points. Address lifetime issues for college-age children, HIPAA waivers and healthcare proxies and powers of attorney. That's what we discussed earlier. Addressing life insurance issues. This is a big trigger point, okay? Addressing lifetime issues for dependent parents. I know those of you, some of you on this call this morning have actually cared for elderly parents, even at a young age. And addressing these issues sometimes drives a young person to want to go ahead and do their planning. And those of you who have experienced this know what I'm saying. Address issues for surviving spouses. Many young adult children are concerned about their surviving spouses and their health and well-being. So that's a given. Address personal care planning. So for the young adult child themselves, not just for others, their own planning, understanding that children that they have, their minor children, are dependent on them. And if they become disabled, their planning, which needs to be in place, is critically important for the stability of the young child that they have, your grandchild, let's say. Addressing COVID-19 issues, addressing financial and tax planning issues, and maybe much more important than being at the bottom of the list, keeping the approach simple. That's a very important thing for a young adult who wants to be, you want to motivate to do planning. Now, I'm going to go through these slides in more detail now, and I'm going to slow down. So addressing guardianship of minor children. So this, again, is the most important consideration for young couples, 44, 45 years of age or under, and even couples that I'm seeing, and probably Gary is seeing as well, who are even 50 years old or older, who have young children, have minor children. So this is a primary motivator and the main psychological obligation of young parents. So that's what you really want to hit on if you haven't already done so, for those of you who are concerned about this. Now, in my opinion, in my experience, this is seen for some couples as kind of a status thing. Well, I've got to get this done because my other friends who have minor children, they've done this, and this is something that I've been putting off. So to me, whether it's a couple or a single parent, this is a checkoff item, something that they want to check off their list and get done. So this is simply maybe a reminder to them. A, the guardianship, B, the planning for the young minor child, C, hey, your other friends have done this and you need to do it. We are in this together. Most young couples are singles with children, see other people that they're going to ask to serve as their guardians. So let's say Gary and I are meeting with a young couple. They say, well, gosh, yes, we have other friends that can serve as guardians, not only just relatives like parents, but we have other friends. Many of them view these relationships in a very positive way. Now, of course, there are situations where there is a young couple or a single person who does not know who will be the guardian. But most of the time, there are potential guardians, and they see these potential relationships as a very positive thing. And in some cases, the person who we're working with, who needs to ask their friends to serve as guardians, they themselves are serving as potential guardians for their friends. So this is something that if you don't already know this is seen as a very positive thing.
One of the sensitive issues that I've run into with some of my clients is when I have young clients with minor children from prior relationships. That is maybe a mixed, a couple with where they brought in children from a prior marriage, and there you have to be very careful, because if you have children from two different relationships in the same household, some of my clients are more concerned with keeping all the children together. Others are more concerned with making sure that the children who came from maybe the husband's prior relationship end up with relatives on his side and vice versa. So that's what I find sometimes is a very touchy issue that needs to be very delicately addressed.
And Gary, could you also speak to the issue that we see where there is a biological parent in let's say a divorce situation where a single or now remarried person is designating guardians of their minor child, but the biological parent that is divorced and maybe estranged is out there, and the issue comes up about whether or not this natural guardian, this parent who is no longer the custodial parent, is really the natural guardian, and the person who's doing planning does not want that person to ever be considered as a guardian, but they in fact are the natural guardian.
Yeah, that also is a very touchy issue. So the first thing we need to realize is that the Supreme Court has ruled that if you're a biological parent, usually you have the number one status to be able to be the guardian of the child. Keep in mind also that in a will we can designate who we'd like our guardians to be, but in the end, it is a judge who has that final decision. So sometimes my clients find it surprising. You can always designate the guardian in the will, but in the end, the court still has to approve it. And if a long lost biological parent comes along and says, you know what, now I'd like to be the guardian, there could be an issue. But what I found though is usually when a parent has been estranged from a minor child, they're usually not all that too anxious to get back involved once the other biological parent passes away.
And not to belabor this issue, Gary, but I've seen many times a parent will say, I realize this is a possibility, but I want to authorize my personal representative to expend the funds of the estate in a substantial way to try to make sure this person does not serve. But, we don't know what the result would actually be.
And in the planning process, it's important to tell the attorney if there is a reason why you would prefer not to have the other biological parent to be the guardian, is to tell the attorney, because in the end, if it does come down to a decision from the judge ultimately is entitled to consider the best interests of the child. So if there are issues that are outstanding with the biological estranged parent that would cause him or her to not be the appropriate guardian, you want to make sure that the attorneys have all the weapons needed to address to the court what those reasons are.
Thank you, Gary. And the last bullet point here is that most children will start the planning process and actually complete an estate planning questionnaire if we remind them of the guardianship issue. So just wanted to reiterate that again as we go away from this particular slide. Okay, addressing trust planning issues for minor children. So we talked about this just a little bit. So I think this is a secondary priority, but just right up there at the top for further trust planning. And most traditional wills are going to say, well, I'm providing for a further trust for my child until they're at least age 25. And opinions are going to vary on this. And Gary and I have seen our share of wills, or even drafted our share of wills that would say age 35 or 30 or a very variety of situations there. So that is a very common concern right up there with who's going to be the guardian. Now, as we look at this issue of a trustee versus a guardian, in many families, in many young couple situations, this is going to be the same person. The person who's going to be the trustee is the same person who's going to be the guardian, and there is no worry about the guardian having access to the funds and the trustee having access to the funds. It's all the same person. That's the family situation and the family dynamic. And then we have lots of situations where the parent will say, I want two different persons. I want this person to be my trustee. I want this person to be the guardian. And in our wills, and perhaps Gary does the same thing, we customize many times instructions for the guardian and for the trustee. So what we want in many situations is for the trustee to be, if they're two different people, we want the trustee to know that they are to go ahead and expend funds for the benefit of the person who's under guardianship, the minor child, regardless of the guardian's resources. Perhaps the guardian needs to expand the house, put on an addition to the house, or buy a bigger vehicle, or needs funding for some particular purpose. So we don't want the trustee to be stingy with the funds. Every situation is different. We want there to be a flow of money. But there are specific reasons why that particular parent did not want the same person to act as trustee and guardian, and that can be customized. Letters of intent or letters of wishes, as we've discussed many times, are underutilized, I think, and parents can articulate, in addition to maybe some custom instructions in the will, they can articulate how they want children to be cared for. Lots of issues about where the child should live, where geographically the child may need to move, and so forth. A trust protector can be used. A trust protector is a special fiduciary, even in these limited trusts that will last only to a certain age. A trust protector provision can be used. And again, we talked about a custom provision about the disposition of funds and a residence. Now, let me expand on this just a little bit. Most couples are going to keep this relatively simple. But what we're going to do here in Gary's firm and Steve Elville here at Elville and Associates, we're going to make sure that the young family knows that they can customize provisions. Perhaps there are relatives that live in another state. That's where the child would have to move if they were under guardianship. Perhaps it's just in another county in the same state. So we want to customize these provisions about giving parents peace of mind about what's going to happen with minor children. Now, addressing planning issues for children with disabilities or other loved ones. Now, this is a primary motivator that usually requires no outside influence. We do see grandparents and others come to us and say, well, listen, my child won't do this special needs planning or this disability planning, so we're going to do it for them. But most of the time, the parents are going to do this kind of planning, and they're going to be concerned parents. So we want to evaluate the disability, the current status of the means tested benefits. We want to determine whether a supplemental needs trust is necessary. In many cases these days, we're seeing lots of in-between situations. And some of you have experienced this yourself. It's not quite clear whether the young beneficiary is going to be able to be high functioning in the world and get along in the world and make a living and be able to gain control of their own lives, or whether they're going to be dependent and it's very difficult to know sometimes. So we include a standby special needs trust many times and go ahead and plan for that young person in a general way instead of a special needs approach. So again, this is just a question of suitability, of fact finding, and this usually requires no motivation on your part or no effort on your part to get a child to do that, hopefully. We also want to address funding issues here, and we want to make sure that life insurance issues are addressed. So in all planning for minors, I think that is a big issue. Jeff, I'm going to stop for just a second here. We've been going now for about 35, 40 minutes, just to see if there are any questions or any comments.
Thanks, Steve. No questions at this time, but if you do have questions, everybody, please go ahead and pose them at any time.
Very good. All right, now addressing college age children issues. So again, this is all subject to an adult child's willingness to participate. They are emancipated in Maryland at age 18. They can make their own decisions, but most college age children are willing to be good sports and sign basic HIPAA waivers, basic powers of attorney, and an advance directive. And that's where I get to the second bullet point here of simplified version of these documents. Simplified version might be the most appropriate. Most young people don't want to think about end of life issues. That's not a problem. They can sign an advanced medical directive and a standalone HIPAA waiver, and they can just make basic decisions. Who is my agent? When do I want their power to be effective? And not have to get into all the intricate details of end of life decisions. And of course, we can use the simple short form Maryland power of attorney. We're going to keep going. We want to address life insurance issues, as I just mentioned. So life insurance, in my view, and Gary may agree, is the Swiss Army knife of estate planning. And we should be using life insurance, especially for young couples. So this is mainly for young couples with minor children, obviously also for single parents. It's usually underutilized. So even though Gary and I and all of our law firms here have nothing to do with life insurance as far as selling the products, and we're not life insurance experts by any extent, but we want to help evaluate the need for life insurance for income replacement, college education, and the support of the minor.
Steve, what I find sometimes is that the younger clients don't usually have room in their budget to pay for life insurance. So one of the types of life insurance that you can get, at the very least temporarily, which is very cost efficient, is term life insurance. So until the couple is able to earn more money, at least with term life insurance, you can get much more bang for the buck.
Exactly. And starting the process, in my opinion, by initiating the underwriting process sometimes is a great thing to do. So not only is this a technique in life insurance sales to start that underwriting process, but I think for getting young people to plan, maybe they don't make the commitment. Maybe they just allow the process to start. the underwriting process, which might include a medical exam and probably would include a medical exam. Get that process started and see how much it does cost. Hopefully, most young people are healthy, and the cost of insurance is, especially term insurance, like Gary said, is very, very inexpensive per thousand. We want to ensure that beneficiary designations are accurate and complete. So this can be a problem. We can end up with improper beneficiary designations. Let's say the parent has done all the right planning, has life insurance, has retirement plans, but the beneficiary designations, something as simple as that, is inaccurate. That could mean that funds go into a guardianship for the minor child and that the minor child gets full access to the funds at age 18. So this can be rather disastrous. And Gary can also comment to this, but when a court becomes involved and is really under the control or controlling that money that is not left in a private trust, but it's in the auspices, under the auspices of a court and guardianship, in my experience, courts can be very tight-fisted with this money, and it can be a real nightmare for the guardian. So
not only that, Steve, that even though it may be very difficult to get the money out, then once the child reaches age 18, they get it all, and that could be even a worse disaster.
Yes, Gary, did you get a lot of money at age 18?
I did not.
I just wondered. All right. We all know what would happen if any of us at age 18 were to get a large lump sum of money. So that would be a bad situation. And we want to utilize a life insurance trust to own life insurance where appropriate. And we're going to talk about that more later. We want to counsel the young person about the upkeep of the policy and the payment of premiums. Even though Gary and I are not insurance professionals, we know from our dealings with financial advisors and life insurance professionals that most term insurance never pays out. And that's usually because it expires before it's ever needed, or it simply isn't kept up and policy premiums aren't paid. So that's an issue of diligence. And we want the young person to know the difference between permanent life insurance and long-term and short-term purposes of it. And I know many of you have been very dedicated to your life insurance and keeping it up over the years. But we don't want the young person to have no life insurance at some point in the future when they need it. So even though affordability is an issue, we want to talk about permanent versus term insurance. And again, we may have relatives that are dependent. Now, what does this have to do with a young person and motivating them? In my view, it was really a lot of young people may not recognize the need for their own planning, but they may recognize the need for assisting other family members in having their planning. And as part of their that knowingness or that knowledge, it may motivate them. So subject to the adult's willingness to participate, okay? For children, to implement incapacity planning and medical information documents as soon as possible. That's what we want. So hopefully by having to live with long-term care situations that they see other family members in, grandparents and others, this would motivate children to do their own planning. Issues for surviving spouses. So I see a lot of this. I see a lot of people saying, well, you know, at this point of our lives, and these are young couples, usually 45 to 50 years old and under, they are not focused on remarriage issues, such as many of us who are over 50. They're not focused on a lot of long-term asset protection issues for their children. They want that short-term protection, and they want to make sure they're providing for guardians, not necessarily the long-term asset protection and comprehensive planning that most older people are concerned about. They are concerned about their surviving spouses. They are not necessarily worried about remarriage and other protections. They just want to make sure that their spouse is provided for. So usually this kind of planning is limited to life insurance and retirement plans and the primary residence, making sure surviving spouses are secure. So again, I've got this down the list a little bit. Gary may have some comments here, but I believe that not only providing for minor children and guardians, not only providing for trusts for minor children, but also really just providing for the welfare of surviving spouses. and making sure that children understand, and this is something I should have put into my bullet points here, that if they have no planning, if they have no will, their surviving spouse will not take 100%. So if I were to die and I were a young person and I had no will, my surviving spouse would not get 100%. They would get much less than 100%. And my children would actually get assets outright, which would cause a guardianship. So this whole issue of providing where the surviving spouse will be in control 100%, that is a really big motivator to make sure the intestacy laws do not control, giving the surviving spouse only roughly 50% of the assets, giving the children who are minors roughly 50% of the assets, and causing a guardianship. And Gary, I know we'll have some comments on this, but another bullet point here before I turn it over to Gary is to make sure that that we raise the issue of the surviving spouse having a mortgage that's paid off. That can be a wonderful thing to put into a will, that life insurance will be sufficient to pay off an existing mortgage or student loans and so forth. So providing for surviving spouses is a big motivator. Gary, do you want to comment about the intestacy issue or other issues here?
Well, if it turns out that somebody dies without a will, then basically let the state of Maryland write a will for you. And what my clients are often surprised to find out is that in the absence of a will, with a few exceptions, half of the assets that are owned by the deceased spouse in his or her own name pass to the deceased spouse, but the other half passes to the children. And if that occurs and there's no will involved, not only would one half of the assets pass to the children, if they're minors, most people assume that if you're the adult surviving parent, you're automatically the legal guardian of the assets that pass to the children, and that's not the case. Without any kind of estate planning at all, if assets are owned in the name only of the deceased spouse, half the assets that pass to minor children must be subject to a guardianship, and the court gets involved. So please don't assume that simply because you are the biological parent of a minor child without any estate planning that you can control those assets. That's not the case. And further, if you've designated a surviving spouse as the beneficiary of a life insurance policy, and the surviving and assets also pass to the minor children, life insurance proceeds to a minor child also would be subject to a guardianship in the absence of any planning. So it's really imperative not only to have life insurance for a surviving spouse, but also in the event that there's a simultaneous death, if the assets are to pass to minor children, you've set up in your will a trust for the benefit of those children and designate that trust as the beneficiary of that policy.
Gary, that's great. And along those lines, I would say, and this is common sense, and many of you are making sure this happens with your children and nieces and nephews and so forth, but try to get them involved with a financial advisor, in my opinion, is a great approach, along with the estate planning attorney. And Gary, as you were describing that, I thought, well, maybe it's a great time to share a simple story. And I know you and I have many, many stories to share. One comes to mind when I was a young lawyer many, many years ago. And I saw a case where a young 9-year-old child was left about $250,000 in life insurance. And the parents were young, very, very nice, very, very caring parents. And a family friend had left $250,000 roughly for this 9-year-old child with, I guess, just didn't think about the ramifications of it. So the court had to get involved, of course, and become the guardian of the $250,000 for the minor child. And as I recollect this story, this minor child was a very lucky child and was going to private school. And so what the parents did after this guardianship was established, and they were very grateful to the deceased person for what they had done, despite the fact that it had caused a guardianship, the parents asked the court if they could use some of the funds for school uniforms. I remember this. And in that particular case, the court had this money under lock and key in what is called a restricted account. And it couldn't be invested by my recollection. It was really just in a basic interest-bearing account with no investment potential. And here the child was 9 years old. She was 9 years away from becoming an adult. So that's a long time for that money just to sit there. Well, the point of my story along the lines of what Gary said is the court refused to allow them to use the money for school uniforms, if you can imagine that. And it really was shocking to me as a young lawyer to see that. So courts will be very, very tight-fisted at times with this money, and it's much better to avoid guardianship by the parents having the proper planning.
Yeah, I had sort of an opposite issue, in which case there was not a real problem. There was also a large life insurance recovery. There was not a real problem with the court as far as distributing assets for the benefit of the children, but there was a $500,000 policy that was subject to the guardianship. And when the child reached age 18, there was about $460,000 of it left, and this 18-year-old child ended up with $460,000. Now, I remember when I was 18, what I might have done with that kind of money. I don't know what happened here, but the family tried to ask me what can be done. There really is nothing that can be done. So this really sort of underscores the importance of not only planning for trusts for minor children, but I generally will counsel clients not to have the assets distributed to the children at age 18. At the very least, I generally suggest age 25 or 30.
Thanks, Gary. I was just sitting here thinking you and Jeff would have invested that money at age 18.
Well, I sometimes have thought about it. My guess is at age 18, I might have, I probably would have bought a lot of baseball cards, but when I was 18, I was in this, in I guess 1970 or so. Had I done that, my parents would have been angry at the time, but I would have been a rich man now.
Exactly, exactly. All right, moving on, and we're going to take a short break here in just a second. We want that adult child of yours or the niece and nephew that's an adult with minor children to think about their own planning. And this is not just to plan for others, but to plan for themselves. So another psychological inroad, I would say, is not just to think in terms of, hey, I've got to do this for my minor children, even though that is the primary motivator, but to take care of themselves, because as you'll see in this second bullet point here, arguably financial powers of attorney, for example, are the most important document, in my opinion, especially for a younger person. And upon their disability, which is unlikely, but possible during COVID, the power of attorney is not only authorizing the agent to take care of them, but to take care of any person who is dependent on them. So by taking care of their own planning, they're taking care of the children, as I mentioned before. So again, that's not what they're consciously thinking about, but this is something to remind them of, that by caring for themselves, they are actually caring for the minor children as a motivation to do planning. COVID-19 issues, again, I'm not going to go through those again, but for most young adults, this is going to be way too much to consider. So if we do planning for young children with grandchildren, with your grandchildren, we're probably not going to put them through all of these COVID-19 issues, although some of them are quite sophisticated as young people, and they will want to address these issues. But we're going to try to keep it more simple for them so they'll get something in place and they won't think it's too overly complicated. But
I do
go
have
ahead, Gary.
About young parents with minor children. I've had this happen before. I'll ask if it's happened with you and what you've done. I've had parents with young children who decide they're going to take a vacation for a week. They're going to leave the kids with an uncle or an aunt or a grandparent. And they've asked me, well, what should we do, Gary, if we're out of town that authorizes, our parents to make healthcare decisions for the kids or our aunt or uncle? What have you done?
Well, that is a great question, Gary. I have encountered this most recently with a client who went to Europe for an extended period, but with their job. And we went through a lot of counseling about this because it had to do with an adult special needs child who was higher functioning, but there was some concern that not exactly what you described, but similar. It was a question of whether he was going to be able to maintain on his own and who would take care of him and so forth. And there had to be a lot of counseling on that issue. And basically what we concluded was that in his case, since he was higher functioning and he was over 18, that he was able to sign some basic powers of attorney and advance directives, and there was an immediate power. For minor children, I don't really have a good answer for you on that because that's a very complex issue. And I think what that comes down to possibly is parents designating, let's say, successor agents who would also maybe have a written authorization by the parent. That would be my best solution, is to provide some kind of a parental authorization form that hopefully, under the circumstances of a healthcare issue, would allow, let's say, the parent's successor agent for a minor, the parent's own successor agent in a healthcare situation to be able to act for the parent, for the parent's children, minor children, while the parent was on an extended leave, and an authorization by the parent as the natural guardian of the minor child, authorizing this person to make decisions. I think that would be the best thing that could happen.
I've done the same thing. And what I've also found in practicing law for over 40 years is that although lawyers can be very strict when it comes to the specific requirements in these legal documents, doctors not so much. And if it turns out that a child's grandparent has to take a child to the hospital because the parents are out of town, with a document that I've just sort of put together, because I don't know there's any actual formal legal Maryland requirement to do that. Doctors are just looking for a way, a bootstrap, to be able to have someone else make the healthcare decisions so they don't have to do it themselves.
Gotcha. Thank you, Gary. Excellent issue. We're almost done this particular segment. So again, addressing financial and tax planning issues for the child, the adult child with minor children. So encouraging them to use financial advisors. We talked about this. Encouraging them to use the financial advisors of parents. I know many of you are successful in doing that, and facilitating the lifetime learning of the child by inviting them into the CCP process as part of family meetings, as part of ongoing events. And of course, most financial advisors want to keep the assets under management where you are doing business with your financial advisors for the long term. And they want to cultivate these kind of relationships. So I think it's continuing to understand that that's where they're coming from. And they want your children to be long-term clients. And of course, encouraging children to be part of the wealth transfer process, involving the children in your own planning goals to whatever extent that you feel comfortable. And again, as I mentioned, encouraging the children to attend the CCP events and begin their own planning. And as we end this particular segment, we are mindful that we want to keep this approach and this process very simple. At our firm, we have a simplified questionnaire that would not be as onerous and daunting as the big one that we normally use, and many of you have dealt with. Gary probably has his own, and he'll comment about that. And we want to provide this questionnaire, okay, at a CCP event or a family meeting. So sometimes we have to kind of nip this in the bud when we have a chance to strike while the iron's hot. If your child is attending a family meeting, maybe we can give them a questionnaire right then and there to gently encourage them to do their own planning. We can treat the planning process as a two-step process. Keep it very simple. No extended meetings, just an initial meeting to get the planning started and a final meeting to review and sign the documents, to keep it simple. So keeping it easy to onboard the child for processing, for estate planning, easy questionnaire, easy video and online process. A lot of them are going to identify with this. Show me the instructions online, show me a video, show me how I can easily take care of this. And of course, our staff here at the office can provide oversight with minor children and assuring the children, and I mean this seriously, about payment arrangements. Some of you may want to help pay for your child's planning. Others of you may say, no, that's not appropriate. I want my child to pay for their own planning. And here we are committed to making sure the planning happens no matter what the child's ability to pay is, as far as I'm concerned, because we want to help facilitate planning for your children and nieces and nephews and others. Now, what I would propose is that we take about a 5-minute break. Jeff, do we have any questions? And I want to give people just a time for a breather and a stretch for 5 minutes as we get ready to start the next segment when one spouse passes away. Any questions, Jeff, or comments, Gary?
Not so far.
All right. Jeff, I
Yeah, so I
propose we
think-
take a 5-minute break.
I think a 5-minute break would be good, and we will get back right at 5 minutes and get started. So looks like actually we did have one question, Steve.
Go right
I'll
ahead.
maybe run that by you right now. So the question is it appropriate to use the Elville questionnaire with children who live in another state?
Thank you for that. Yes, it would be appropriate. Depending on on the state, of course, the laws may be different, the laws of execution and so forth in those states, but the information is going to remain the same. So I think that's perfectly fine. Thank you for that.
See you in 5 minutes.
Thank you, Gary. Okay, Jeff, we're going to start here in just a second.
Sounds good, Steve.
All right, I believe we're just about at 5 minutes, so I'm going to go ahead and get started again. All right, so thank you, and we're going to continue now with the second half of our CCP event, planning considerations when one spouse passes away. And my view of this, many of you have asked to hear about this, so I want to make sure we're comprehensively addressing it today. There's a lot to cover. I think to simplify this subject, I think there's a couple of different viewpoints on this. First of all, when one person passes away, especially when a person passes away with a revocable trust, this is one of the most confusing things in the world of estate planning. What happens? Well, what becomes even more confusing is what happens when one spouse passes versus when two spouses pass. So I'll try to make this as simple as I can. In my opinion, when both spouses pass away, this is where the big administration occurs. This is where the big full-scale administration of a trust or an estate occurs. Usually when the first spouse passes, the administration is less onerous. It's less involved. Not always, but usually. I'm going to say about 75 to 80% of the time. So I hope that helps, that what we're really talking about here is when one spouse passes away and there's a surviving spouse. So I'm going to break this down into two categories. The pre-mortem issues, meaning both spouses are still living and then one spouse dies. But in this first set of bullet points, there's one spouse still living, and then the post-mortem issues. So let's get right into the bullet points. So the next 2 or 3 pages are all bullet points, and then we're going to get into the actual meat of the subject. So lifetime asset alignment. Are all assets properly aligned, including assets passing to the spouse or in trust for a spouse? So remember, both spouses are still living in my example here, pre-mortem issues. Have all trustees and trust protectors been considered and fully reviewed and updated prior to the death of a spouse? Powers of appointment. Have all powers of appointment in favor of spouses been considered? So remember, if you are a person who has inherited a trust from someone else, you may have been given the power of appointment to appoint the property in your trust to a spouse. Remember, some of you are doing this in your own planning for your children at your passing. But this example says you're both still alive. You as spouses are still alive. And now are you in possession of a power of appointment that you need to exercise or would want to exercise? Have all disability-related planning and asset alignment issues been addressed prior to the death of a spouse? I know that's very fundamental. Has a planning team, CPA, financial advisor, estate planning attorney, been established for the use and benefit and advice for a potential surviving spouse? So some of you I know are very good about this. You have thought about your surviving spouse and you've said, I want to make sure that he or she has access to a team. And that's a wonderful thing that's going to make life much, much easier for them after the death of a spouse. Lifetime asset alignment. So I apologize. So in this particular pre-mortem process that we're talking about, there was only one set of bullet points. We're going to get into the more comprehensive bullet points on the post-mortem issue. But here we have these 5 bullet points that I've laid out for the pre-mortem issues. Let's get into the meat of that subject. Lifetime asset alignment. Are all assets properly aligned, including assets passing to spouses in a trust or outright to a spouse? Now, I know early on in our presentation, we talked about asset alignment. I'm beating that drum because I believe it is arguably the most important thing in estate planning. So just remember, asset alignment can fail. Someone can have a large IRA and it does not go where they want it to go because beneficiary designations fail. It got accelerated income tax because the beneficiary designation failed. Or they meant it to go to a trust for a spouse, but it went outright to the spouse. And I know these are very simple things, but they can cause huge issues. So we want absolute certainty in the titling of assets and how beneficiaries are designated, okay? Again, We want clear definition of how things should be designed. Many of you have accumulated very large amounts in retirement assets. And many of you as spouses have decided, well, in certain cases, I'm leaving our retirement assets outright to a spouse, or in other cases, I'm leaving it to a marital trust or other trust for my spouse. So what we don't want is we don't want that to go in any way that we don't want. We don't want that to be thwarted. So if we are leaving assets to a marital trust, we want to understand how the surviving spouse will have those assets in the marital trust. We want them to understand that that is an exempt transfer of assets for Secure Act purposes, as long as that trust is designed, that marital trust is designed the right way as a Q-tip marital trust that is also a conduit trust. And these are technical things, but my point is it's these little technical nuances that's going to make sure that your plan works the way that you want it to work and the asset alignment is correct.
Steve, what is a Q-tip election?
Thanks, Gary. Well, the qualified terminal interest property election, this is an election that Uncle Sam has established that basically says that if we are choosing to have assets passed to a surviving spouse in a certain way, then we have to make this election within 15 months. So the election is due within 9 months or with an extension up to 15 months. But that election is made on Form 706. And that's just one example of making sure that assets are aligned properly. But moreover, in this particular illustration, that the spouses understand what's going to happen on the death of one of them. That's the education issue. And all the mechanics are right. All of the education is right. And this is going to cause much less stress on the survivor, but it's also going to provide clarity and make things work the right way. Have all trustee and trust protector considerations been reviewed? So again, if we're keeping things simple for the surviving spouse, this is not going to be a big issue. But if we are leaving, necessarily going to be a big issue, but if we are leaving assets to trusts for the surviving spouse, we want to make sure that we've reviewed who the trustee is going to be of that trust for the survivor. Do we want the survivor to be the trustee, or have circumstances changed and we want an independent trustee or a co-trustee with the surviving spouse? And are the trust protector choices what we want? Are we comfortable with those trust protector choices? Because remember, trust protectors can wield very large powers that are for flexibility and assurance of the surviving spouse. So we want to make sure the surviving spouse feels good about the trust protector that's going to serve as a flexibility mechanism. Powers of appointment. We talked about whether you are a person who actually has a power of appointment over a trust. You may not have inherited a trust from someone, and you may not have a power of appointment, but if you do, you may have a power of appointment to exercise the power in favor of your spouse. So that's something that you want to think about as we think about what happens not only for our basic planning, but for any trust that we've actually been left by someone else, and whether we have a power of appointment in that trust before the death of one spouse.
One of the important aspects about a power of appointment is that over the next couple of years, and I think we may get into a little bit, we may find the estate tax rules change dramatically. And one of the things that could happen with the changes of the estate tax rules is as bad as the estate taxes, there's something worse called a generation skipping tax. And if the exemptions are lowered and we have a large estate and you're leaving things to maybe grandchildren, that could negatively affect taxes. But with the power of appointment, we can actually change the terms of the trust and possibly lessen the effect of any of these new taxes that could be coming down the pike just in the next year or two.
Thank you, Gary. And finishing up the pre-mortem issues, have all disability-related planning and asset alignment issues been addressed? So this is a function of the simplicity of your annual and biannual reviews for CCP, or it can be the result of a Medicaid plan or a shift in planning from traditional conventional estate planning to more of an elder law type plan. So again, the kind of planning can change over time, and that can change the post-mortem considerations, not only the pre-considerations, but the post-mortem considerations. Now, has a planning team been put in place? So I'm kind of being redundant here on purpose, We want to make sure that you have a planning team. Most of you do. And we also want to make sure that your planning team is talking, that they understand your situation and that they are collaborating. Okay. So in the interest of time, I'm going to move on now to the post-mortem issues. And this is really the heart of this discussion. So we want to understand how assets flow at death. Again, flow. I want to emphasize that word. And this is where we're going to have many bullet points. I'm just going to go through them initially. Then we're going to get into the meat of the subject. I want you to think about this idea of flow. How do assets flow on the first death? And that's going to help you a lot. Understanding resources that are available to you on the death of one spouse. So the survivor of you needs to understand that resources are available. Most of you know that. We want you to access those resources. Now, speaking of access, we want to have access to funds. Many of you are very concerned about this, and you should be. On the death of one of us, how will we access funds? I don't know if Gary has experienced this recently, but over the summer and even up through just recent weeks, I am seeing that we are having difficulty and a very slow process of getting access to funds on the death of one person. Now, these are not necessarily spousal cases. The cases I'm referring to are cases where a single person or a surviving spouse died, and now the continuing trustees are having difficulty accessing the funds, meaning they're having difficulty getting the large institutions to transfer the control of funds. So I would say this is an issue to be concerned about, especially since COVID-19, and many of the firms, the big institutions, many of them are understaffed and so forth. Gary, are you seeing any of this in your administration?
I am. And,
Okay.
and I can tell you, it seems to me it's about 90% related to COVID delays. And the other 10%, there are certain banks and financial institutions which I've simply found historically difficult to deal with. Without mentioning any names, I'll tell you one of them is a bank right here in America.
Gotcha. All right. Well, we want to have access to funds. So in will situations, revocable trust situations, jointly held asset situations, payable on death and transferable on death account situations, with regard to deeds, and I'll just throw in irrevocable trust, life insurance claims, and death claims for other assets. And moving on, obtaining date of death valuations. This is important in the post-mortem process. Understanding probate versus non-probate for the surviving spouse. Understanding the administration process in general for the surviving spouse. And those of you who have accessed your handout, just know that on our side, we were trying to make sure that you have some kind of idea of what we're talking about the post-mortem process. These handouts or checklists are really a general kind of overview of what should happen on the death of someone. But as I mentioned, the bigger process of administration is usually on the death of both spouses. So I just want you to know that these kinds of processes and checklists exist, and many of you have seen these before. But we also want you to know that in most spousal cases, it's not going to be as comprehensive as this list appears to be, but there are still steps that you need to walk through when one spouse dies and one survives. We want to retitle assets in the name of the surviving spouse or his or her revocable trust. We want to retitle assets in continuing trusts for the surviving spouse. And you may find this a funny bullet point, but we want to avoid a sense of urgency. We don't want to be too urgent. Many times, and you've seen this yourself, many times a surviving spouse will have this tremendous sense of urgency to get things in order and put themselves through a very uncomfortable situation too soon. So we want to fine tune this and have kind of a happy medium between acting too soon and also taking care of oneself if you're the surviving spouse. We want to understand claims of creditor issues in probate or non-probate. We want to understand the 1040, the final tax return for the deceased spouse, the 1041 for administration. We want to make the Q-tip election. We also want to make the portability election. And both of these are done on the Form 706. We want to understand spousal elective share issues, and we want to make sure that we're updating if we're the surviving spouse, that we're updating our own documents And that's what I was just mentioning. We don't want to be doing that too soon. Meaning we don't want to cause ourselves a lot of emotional distress, which I'm going to talk about in these bullet points. Now we're running a little bit behind, and I'm going to just move as quickly as I can through these more comprehensive descriptions. So we want to understand how assets flow on the death of the first spouse. So this is probably the most important consideration in this entire presentation. So understanding what your intentions are. If it's simplicity and outright distribution, we want to understand how that will work. This is something we can focus on in CCP meetings and in family meetings and in meetings with financial advisors for updates. We want to determine the cohesiveness and success of the spousal plan. Now, what do I mean by that? What I mean by this is, and Gary may have comments here, is we want to make sure that both spouses agree on this, really agree. Because I have seen situations many times where one spouse dies and how assets are titled for the spouse that survives is actually not in coordination with the planning. And we want to make sure that that does not happen, especially we want both of you, if your spouses, to be on the same page. And I'll get into this in more detail. We want to make sure that surviving spouses understands the resources available to them. This is basically a function of the planning team concept, continuing education, partnership with the law firm, and your annual or biannual reviews. Obtaining access to funds. Now, in wills and probate, the surviving spouse usually is going to have received most of the assets without probate. If you are a traditional couple, which not everyone is, but if you are a traditional couple, most of you know that on the death of one of you, the survivor of you will get all assets or nearly all assets without probate. But in many situations, the first spouse to die will have some asset in their own name with no beneficiary and no joint owner. So that will go through probate. And if that situation happens, hopefully the survivor has access to their own funds or the funds of the deceased person through joint ownership. So understanding that joint ownership, the survivor should go in and take control of those funds. Back up to the second bullet point, if there is a revocable trust, we have a non-probate administration. Now, in a revocable trust, we have the same exact concept as we have with a will. There is either outright distribution or there is distribution into further trust. The surviving spouse is going to have his or her own revocable trust, and they're either going to have outright distribution from the deceased spouse, or they're going to have distribution into further trust. So again, this is counseling about the flow of assets, what specifically happens with the flow of assets on the death of one person. Payable on death and transferable on death account. We need to understand how those accounts are designated. It sounds very simple, but it is possible for a transfer on death account to be actually designated to a trust. We need to understand how those designations work, and we need to look on our spreadsheet and say, how is that particular account going to flow at the death of one spouse? So there's no surprises. Deeds. Should retitling occur? So let's say that we have a deed, and that deed is titled as husband and wife, spouses, tenants by the entireties. Many spouses that inherit the property by automatic operation of law, meaning the surviving spouse, will say that to us, should we retitle the deed in the name of our own sole name? And in my opinion, that's not always necessary, but sometimes it's a nice thing to get cleaned up. If the surviving spouse is a person who has their own revocable trust, then the primary residence should be retitled in the name of the surviving spouse. So there could be, and maybe should be, deed retitling. There could be POD or TOD accounts. Surviving spouses need to take control of those accounts. Jointly held assets, they need to take control of those accounts. Revocable trusts, they should hopefully be able to take control of those accounts quickly, although Gary and I are having some issues with that. And all you can do there is be very diligent. And hopefully the survivor has his or her own funds that can see them through at that time. Some people will title assets in joint accounts in limited amounts, $15,000, $20,000, $25,000 to get through any kind of bump in the road that could happen on the death of one spouse as far as access to funds.
See, if I could emphasize how important it is, especially when the children are adults, for the adult children of the clients to know what kind of plan you have. Because I had one case about 10 or 15 years ago where the husband and wife died. They both had revocable living trusts. They died in a very short period of time. And when the husband died, the wife was already ill. And so the family didn't really come in to see me. About 10, 15 years later, the children came in trying to apparently sell the house that the two of them owned together. And one of the kids lived in a house after both of them died. And when they tried to sell the house, there was a title problem. The problem was the home was still in these trusts that were created 20 years ago when both of the parents died 15 years ago. So it's not only important that if you're married, that the surviving spouse obviously know how the plans are to work, but it's really important to keep the children involved. And that's one of the benefits of the client care program, is to try and also educate the children as well, because you'd be surprised how often the children assume, well, if everything's in the trust, we don't have to do anything. So really, we need to get the adult children involved as well.
Thank you, Gary. And with irrevocable trusts, such as life insurance trusts or other irrevocable trusts, we need to understand how these work and the flow from one deceased spouse to the survivor. For example, in life insurance trusts, the idea is to keep the assets out of the estate of the first person to die and out of the estate of the surviving spouse, but to still have those funds available for his or her use. So understanding how these things work is important for peace of mind and to understand post-mortem processes. Life insurance claims. Many spouses will make life insurance claims immediately, very quickly, without any regard to the estate plan and how assets are supposed to flow. And in the times in the past when we had lower estate tax exemptions, and we need to use disclaimer planning, which may come back in the future as a more pertinent issue if the exemption amounts come down. Sometimes spouses claim life insurance too quickly, and they take possession of it and they put it in their own bank accounts when we need to be considering what's going to happen with life insurance to keep it excluded from estate tax and so forth. Death claims for other assets, how to do those and when to do those. Very important. There's a timeline for claiming retirement plan benefits, and that timeline starts in the fall of the year following the date of death. The fall of the year following the date of death. And we won't go through all that right now, but it's important to understand those things for peace of mind and getting through post-mortem issues. Obtaining date of death valuations. This is a very important step after the death of a spouse, especially after the death of both spouses, but I would say it's very important even on the death of one spouse to establish cost basis. There are certain situations where there are business interests or other special valuations. And of course, we want to account for all income from the date of death until the time of distribution, even for a spousal administration, which again, to make things not as onerous as far as understanding this, that's a much more simplified process in most cases, not all cases, than it is when two spouses die. Understanding probate versus non-probate for the surviving spouses. Many of you have seen our trust administration or estate administration workshops, and you've seen Gary put on these various workshops. So you know that probate administration and trust administration are similar processes. They're similar in some ways and different in many ways. They have similar concerns. Many times a streamlined or limited process, of course, at the first death is what we're dealing with. But you need to understand as a surviving spouse, if I have a will, what's going to be the administration process? Does my deceased spouse have any probate assets? If not, then we're not worried about it. In a revocable trust, we're not going to have to worry about probate as long as we've maintained and updated our plan. So in a non-probate trust administration, the surviving spouse is either going to be retitling all assets in his or her own surviving continuing revocable trust, or they're going to be retitling assets in further trust. And that's where we're here to help in both circumstances. So again, trying to cover this the best way we can. We have processes for probate. Hopefully there's no probate if you're a traditional couple. However, there are going to be non-traditional situations where the deceased spouse has assets in their own name. Okay. I urge you to take a look at these checklists and understand the various things that there are to consider on the death of one spouse or both spouses. And then again, in non-probate situations, we're going to be concerned about some of the same issues, but we're not going to be concerned about jumping through hoops with the Register of Wills. Now, let's get into the retitling of assets as quickly as we can for the surviving spouse, either outright or in the revocable trust for the survivor. Sometimes this happens too soon, and the attorneys that are involved cannot help because the surviving spouse has titled assets in his or her own name very quickly. So some of the post-mortem tax issues cannot be properly evaluated. So we don't want this to happen. And again, sometimes this occurs in a way contrary to the provisions of the will or trust. Now, that may be shocking to some of you, and that's why I want you to be on the same page if your spouses. How is this going to work, and are we committed to it? Because sometimes by the time we are informed, not all the time, but sometimes by the time we are informed of the death of someone, and this happens, I would say about 20% of the time, so I don't want to imply that it happens all the time. A surviving spouse has already taken control of the assets and has already retitled them in his or her own name, when possibly the intention of the trust was to continue that assets in further trust for the protection of the survivor and for the control of the deceased spouse. So believe it or not, that can happen, and it can happen in a way that's contrary to the intentions of the deceased spouse. And oftentimes, I will blame our financial advisor friends for acting too quickly and not working in concert with the attorneys. So the titling needs to be done accurately. It needs to be done timely, but not too quickly. And the assets of the surviving spouse should be checked and double checked in their own continuing asset alignment, in their own continuing plan. Gary, we're running behind, but do you have any comments about this? And have you seen this happen?
No, I have from time to time, but one thing I just want to comfort everybody is that these decisions are not decisions that you all will have to make. These are the decisions that your professionals will be making. So all the advice that we are giving to you this morning, the main piece of advice is, as soon as all the personal issues are taken care of, come see us or whoever your professional advisors are. These
Thank
are
you,
all
Gary.
very technical things, and it's really not your job. It's our job to determine the best course to go. We would just need you to come in as soon as you can.
All right. In the interest of time, I'm not going to spend a lot of time on this slide. We want to make sure that when the surviving spouse does his or her continuing planning, that all assets are looked at again as if everything was fresh and brand new, to make sure that all assets are retitled in the surviving spouse's trust if we are using a revocable trust. Timelines for retirement plans are adhered to. All of the mechanics are adhered to in coordination with the planning attorney and the CPA. Now, again, we don't want to be too urgent. We don't want assets to be claimed or retitled or sold or recharacterized too soon. We don't want to trip up. We don't want to cause problems when everything up to that point has been done perfectly. So in the post-mortem process, we want to be methodical and organized. And most of you and most of our experiences with clients are that is the case. We want to have reasonable urgency, but not extreme urgency. We want to understand claims of creditor issues. Claims of creditors can occur in an estate where the creditor has 6 months from the date of death, not from the date the estate is open, 6 months from the date of death. And of course, Medicaid and other creditors are not limited, especially Medicaid, is not limited by the date of death, 6 month period. So there are exceptions to the 6 months. For revocable trust, creditors can make claims against a revocable trust since 2014, the Maryland Trust Act. So a best practice is to try to limit the claims of creditors, even in my opinion, on the death of one spouse, to run the statutory notice, even if you have a revocable trust, to limit the claims of creditors, even upon the death of the first spouse, and even if you think that there are no creditors. again, various points of view on this, but I think a best practice is to try to avoid the claims of creditors by notifying creditors that someone has died, even in a trust. Final income tax returns have to be prepared. The 1040 has to be prepared for the deceased spouse, final tax return. Form 1041 for the probate estate and the trust administration has to be addressed. And these are common things, especially on the death of both spouses, but even on the death of one spouse, if on the death of that one spouse, there is going to be a more substantial administration. If it's more of a simple administration where we're just transferring everything to the name of the survivor, then we may not have a lot of 1041 filing requirements, but we want to be aware of our timelines. We want to be aware of our critical dates, and we want to rely on the CPAs and the attorneys. The portability election has to be made within 24 months. The government is being very liberal in this. This is crucial in many spousal plans. So one of the biggest things, in my opinion, that the survivor needs to do is to make sure that he or she is counseled and advised about filing the Form 706 and making the portability election, if that is a sensible thing to do. And in my opinion, it's probably the norm of what should be done. So we need to understand the nuances of the portability election about remarriage and the potential to lose the exemption amount of the deceased spouse and so forth. So I see the Form 706 and the portability election for the surviving spouse as a preventative measure, because the exemptions are slated to go lower in 2026, even if Congress does not lower them before that. Gary mentioned the Q-tip election and other elections. So this memorializes the marital trust election, and that's also done on Form 706. And for those of you who have the Clayton election as one of the formulaic clauses in your trust or will, the Q-tip election is part of that consideration of the Clayton. For the Clayton election, that has to be done within 15 months. So these are post-mortem issues for the surviving spouse. Understanding the new spousal elective share laws. This is not going to apply to most of our clients who are leaving almost all their assets to the surviving spouse, but it does have some implications where we are not leaving assets all to our surviving spouse, or whether we're doing Medicaid planning. So the new spousal elective share laws are such that they are requiring that a minimum amount go to the surviving spouse. We need to understand that. And if we are the surviving spouse, we want to be cautious about remarriage if that ever comes down the line, and make sure that we are protecting ourselves and our estate from the spousal elective share possibility of the new spouse by having a prenuptial agreement. Updating current estate planning documents. I mentioned this earlier, surviving spouses often do this way too often. It's painful for them. It can actually be so painful that it's counterproductive. And we don't want that. We encourage updating, but in a reasonable way. And we want to make sure asset alignment is done. Gary, do you want to speak to the issue of the surviving spouse and his or her coming in so soon that it's very painful?
What I find, it's not so much a legal issue as much as it is an emotional issue. What happens often is shortly after the first spouse dies, the surviving spouse is depressed. Sometimes you get paralyzed emotionally. So it's really more of a personal issue, I think.
Thank you, Gary. And because we're running behind, and I apologize, we will try to continue as expeditiously as we can. I'm going to give you a few slides here on the current tax situation. Then you're going to see many slides that we included back in the March presentation, just showing you some advanced planning techniques. We're not going to go through those today in the interest of time, but I want you to know what the current tax situation is, and many of you are very educated about this already. President Biden has now been in office for a year almost, and the Democrats still maintain a majority in the House, and with President Kamala Harris, Vice President, I should say, they also have control of the Senate. So despite this majority, so to speak, Congress has failed to really do anything comprehensive, even though they've been talking about it for a long, long time. And so part of these next few slides is really going to be, what does this mean for you now? We've had some CCP meetings with some of you, and basically it's a lot of hurry up and wait. But hopefully what you're going to get out of these next few slides is there are some things for you to be thinking about. Now, the new Infrastructure and Investment and Jobs Act was signed into law And it does include lots of provisions for bridges and roads and highways, and you're familiar with this. But it doesn't have a lot of tax provisions, but it does have some. I'm not going to take our time to go through this particular slide. As we know, interest rates are historically low. We've got a lot of inflation on the horizon, it looks like, big inflation numbers. And then we have a huge federal deficit, and taxes are going to likely be increased, even though it has not happened. And I want to emphasize that. Taxes will likely be increased. They haven't happened. It hasn't happened yet, but it still remains likely, in my opinion. And Gary may have opinions here when he's getting his last discussion here of the day, which is the legislative update. So what's going to come next? Here is a quote that I received from the large CPA firm BDO. It says, the focus for tax legislation activity remains on the House of Representatives, which is expected to vote on the reconciliation bill known as the Build Back Better Act in the coming weeks. If the reconciliation bill passes in the House, it will move to the Senate, where the administration will need all the votes and Vice President Harris's tie-breaking vote to pass the legislation. So basically nothing has happened other than some very limited tax legislations on the very, very wealthy. What will the Build Back Better Act actually contain? Well, we don't know for sure, but this is what is currently being considered, that the state and local income tax deduction cap would increase, and then it would be reduced back to $10,000 in 2031. There would be a new 5% surcharge on modified adjusted gross income in excess of $10 million. That's for the very rich, obviously. The new 3% surcharge on modified gross adjusted income in excess of $25 million. Corporate income tax seemed to remain unchanged. New 15% tax on corporations and so forth, with profits exceeding $1 billion. And then a broad overview of the social aspects of this, as many of you have read. Lots of social infrastructure, child care tax credit extensions, earned income tax credit extensions, clean energy. Some of you may have seen bolstering the IRS's powers in one of the prior slides. That's something we're keeping our eye on, and that's here in this slide as well. Increased IRS funding for oversight. But in the interest of time and making sure that Gary has his time, here are the things that we were so concerned about and still are. The increase in federal estate tax rates, as Senator Sanders and others proposed. This has not happened, just to make sure you're aware of this. Decrease in the exemptions. We were told the exemptions could decrease. The exemptions for estate and gift tax could increase to 5.5 million. This has not happened. Increase in federal income tax rates. This has not happened either. Reduction in federal income tax deductions. Well, there have been some that were passed by that recent infrastructure bill, but not very many. Can Congress pass laws retroactively for taxes? The answer is yes. We talked about this back in March. So what do we do as we go into the end of 2021 and 2022? Well, we have to be aware that these things could happen. There's not a whole lot you can do except educate yourself and be active, proactive on certain things that may affect you. Now, we talked about, again, earlier, what happens if the estate tax exemptions are lowered? This has not happened. In 2022, the new estate tax exemption is expected to be 12.6 million, 12.6 million per person. So just know that this has not happened, but it could happen, and it's slated to happen in 2025 or prior to January 1st, 2026. We're not going to be redundant here. The step up in basis has not been eliminated. This has not happened. This was one of the big things proposed by Senator Sanders, Senator Van Hollen's STEP Act, that Senator Wyden has had many proposals. This has not yet happened, and we will keep you informed about that. I will skip the slides about the step up in basis and how that works. I hope you will review this. When we're talking about the step up in basis, we're talking about the ability to inherit assets that are non-retirement assets, inheriting them at a new fair market value cost basis, and therefore no capital gain. There has been talk about eliminating that, very serious talk. That has not happened, and we don't expect it to happen anytime soon, although Congress can make things retroactive. Income tax changes like expansion of the Social Security tax and so forth, these things have not happened. Expansion applying to earned income over $400,000 and so forth, these things have not happened. The new marginal tax rate, as I mentioned, of 39.6 has not happened. So what do you do? Well, some of you have planned proactively. And if you did, as you'll see in our new newsletter, if you're an Elville client, you're going to see in my new article, I congratulate you for that. And I don't think you should have any doubts about what you did. If you did proactive planning in 2021 or even 2020 in advance of the end of 2021 year, I congratulate you, and you should not doubt that you did the right thing, because changes will be coming, in my opinion. So what do we do as I get ready to allow Gary to take over? Well, we need to revisit advanced planning. Now, some of these advanced planning concepts are not going to apply to a lot of our clients, but for those of you who want to revisit some of these issues, I'm going to give you some of the ones that are most likely to apply. A lifetime Q-tip trust. This is a asset protection play where you can provide asset protection during life for a spouse. A spousal lifetime access trust. This is going to be a technique we talked about last March, where you can make a large gift to use some of your exemption or all of your current $11.7 million exemption. This is not going to apply if you don't have assets exceeding at least one exemption amount. If you have assets that is lower than one exemption amount, this is probably not going to apply to you, but you need to be aware of it. The hybrid domestic asset protection trusts and so forth, we're not going to get into that, but I will take you down to the grantor retained annuity trust. This was very, very strongly recommended to be eliminated under the proposals that have come down through 2021, but it has not been eliminated. The tax changes have not happened. And so for many of you, this is going to be a way for you to remove assets from your estate by gifting assets to a trust. And if those assets were to grow in a manner that it outperforms the federal rates, the federal interest rates, then the excess amount is excluded from your estate. So if exemptions lower, this could, and they don't get rid of grantor trusts like a grantor retained annuity trust, this is going to be a very important thing. Charitable giving, many of you are charitably inclined, and we want to talk about outright charitable gifts versus using charitable trusts. We're always here to talk about that. One of the most important things I'll end with, and turn this over to Gary, is the irrevocable life insurance trust. Congress proposed in 2021 to potentially, especially in the September House bill, House Ways and Means Committee bill, to eliminate the traditional use of life insurance trusts. So that has not happened, and a group of lawyers I'm familiar with has basically formed an opinion that the insurance lobby is so strong that Congress is not likely to get rid of the life insurance trust structure. But I still think it's something to keep in mind that we may need life insurance to do wealth transfer. If the government lowers the exemption amounts in the future, that's going to mean that's less wealth that you can pass along and more taxes that your assets may be subject to. And you can use life insurance as a tool for wealth transfer. And many of you are considering life insurance as a wealth transfer tool for Secure Act purposes, to make sure that when your children or grandchildren or other beneficiaries have to pay tax on an accelerated basis because of the Secure Act and the 10-year rule for most people, that you're using life insurance as a wealth transfer tool. The other thing that I will say is Roth conversion. Talk to us, talk to your financial advisors and your CPAs about Roth converting, if it makes sense, as a tool to deal with increased taxation and limiting the loss to beneficiaries. If you can somehow do the Roth conversion, if the government doesn't limit the use of Roth conversions during your lifetime. So irrevocable life insurance trusts, Roth conversions, charitable giving, and understanding Q-tip trusts and spousal access trusts, those are the things that I would focus on, in addition to the GRAT, the Grantor Retained Annuity Trust. These are the basic tools that we are going to want to be mindful of, that the government wanted to take away a lot of the benefits of these trusts, and hopefully will not happen. And if we hear that it will happen, many of you may want to consider these tools before they go away, and hopefully they will not. Now, I'm going to skip through these slides in the interest of time. I apologize for just running through these, but we're running about 15 minutes late. And I want you to know that these advanced planning slides are in here. It's in this slide deck for your use. For example, the generation skipping trust. Many of you have these generation skipping trusts already as part of your planning, the dynasty trusts, so to speak. But I'm going to get to through all of these examples and get to Gary's end of our CCP meeting legislative update. And I would hope that you'll use these slides as tools to further educate yourself. We simply just don't have time for all of this today. Gary, I'm going to turn it over to you.
All right. Let's see. Are you all still there?
Yes, we're here, Gary.
I'm trying to see where my how to get my screens up.
Well, I have the presentation if you just want to go follow along with that.
Good.
But-
I'll tell you what. How about when it's time to move a slide, I'll just ask you to move the slide, all right?
That's fine. And Gary, do you, if you'll need to stop sharing your screen because I think you're sharing your screen right now. All right. And I'm going to share mine again. Jeff, you may have to give me the authority to share my screen again.
Let me see what I can do here.
And Gary, I think you may be still sharing your screen.
Yeah, I think we ought to just go through yours.
All right.
Okay,
Very
there
good.
we go. So
All
Steve,
right,
you
thank
should be
you
able
so
to go
much.
ahead now.
Thank you so much. All right, Gary.
All right. So is there a way so I can see the screens up on top? I mean, the slides? I don't see them on mine.
All right.
Steve, can you go ahead and start sharing your screen?
Yeah, let me get to my sharing. And all right. Here's what I'm going to do very quickly so we don't hold everyone up. I'm going to rejoin the meeting. Oh, don't need to. All right.
If you go down to the bottom there, should be that green button that says share screen.
Yeah, I'm trying to do that, Jeff. Hang on just a minute. I apologize. And let's see. I'm going to there we go. I've got my screen up again. And my challenge seems to be, Jeff, that I need to find
Tell you what,
we're almost there. I just have to get back to the PowerPoint, Jeff. Just a moment. There we go. All right. Should be able to do it now. There we go. There we go. You should be able to see that now.
I see that. Well, I did a second ago. I don't now. I see the very first screen.
Okay, Gary, do you see?
I see
this?
the screen. There you go. Let's go to the next slide. All right.
Thank you.
All right. So there have been 4 or 5 relevant changes to the law in Maryland regarding estates and trusts and guardianships. The first change to the law was House Bill 1000 regarding guardianships. And this new law basically says that in Maryland, if the guardian is not a family member, but distributes assets to a family member being either a child, parent, spouse, sibling, aunt, or uncle, those distributions may not be made without advanced authorization from the court. And if a guardian makes an improper distribution from the estate of a minor or disabled person, the guardian can be held personally liable. If you go to the next slide, please. A guardian may distribute assets from a guardianship estate to or for the benefit of a minor or disabled child for clothing, support, care, protection, welfare, or for the rehabilitation of a disabled person. Assets may be distributed to persons legally dependent upon a minor or a disabled person with court approval, or to establish a special needs trust subject to court supervision, or if a trust is made a first party trust that's subject to the supervision of the state attorney general. Once a minor becomes the age of 18, the assets in that guardianship estate must be distributed entirely to the now no longer minor child. That is, once the child reaches 18, all the assets in that estate must be distributed to the 18-year-old. We talked about that earlier. That could be a planning disaster. So as you can see, we want to try and encourage clients from coming up with estate plans where guardianships for minors or disabled adults can be avoided. Next slide, please. There's a new law in Maryland regarding the execution of wills and powers of attorneys and advance directives. Basically, this new law now allows a will or powers of attorney to be signed electronically. Now, I will tell you that I've read this law about 2 or 3 times, and I'll be honest with you and tell you that I'm not able to decipher from the actual law whether or not you can have what's called an electronic will. Steve, have you read this new law and try to figure out what it says?
Yeah, I've read it too, Gary, and I've concluded right now that Maryland allows or will recognize an electronic will from another state. For example, Nevada is very popular for electronic wills, but I believe this law really just speaks to being able to electronically, in the presence of electronic witnesses and so forth, execute documents and not necessarily allowing an electronic will. But again, this is something that we're trying to get our minds around.
I agree. And again, it's effective. It became effective on October 1. So I'm not sure enough time has elapsed in order for us to figure out exactly what the law means. But I will say this, that wills and powers of attorney can be signed electronically. It can be done remotely. And here's how the rule works. At the signing, the person who's signing and the witnesses must be either in the physical or electronic presence of one another, and there has to be a supervising attorney. The supervising attorney can be a witness, but it must be done either in the physical or the electronic presence of an attorney. At the time of signing, the testator, that's the person who's doing the signing, must be a resident of the state of Maryland or physically located in the state of Maryland or in another state if that other state's laws will basically constitute the jurisdiction of those documents. In other words, if it's a person who's living in Wisconsin, the person has to be actually located in Wisconsin. Any witness in the electronic presence of the testator when signing must be physically located in the United States and must be a resident of the United States at the time of signing. The person who's signing the will or the documents, called the testator, and the witnesses must actually sign the same instrument. And the supervising attorney must create a certified copy of the documents that are actually being signed. Electronic presence basically means 2 or more persons who can communicate in real time using either electronic audiovisual means to the same extent as if they were in each other's physical presence. I will say this, though, I think there are risks involved in remote witnessing and signing. And the reason is, if there is an adult who might not be entirely healthy or may be subject to duress or undue influence, I'm sort of old school. I don't know how Steve is. I would prefer not to use electronic signing, because if there is an issue later, as far as undue influence, being the attorney, the supervising attorney, I'd like everybody to be in my presence, and I would like to know who else may also be in the room at the time of the signing. The next law involves probate cases. I'm involved in a lot of probates where after the probate closes, especially in small estates, a check arrives payable to the estate or to the person who died. And then previously what we had to do was actually reopen the estate and go through the entire process of doing an amended inventory and an amended accounting. But this new law in Maryland basically says that after an estate is closed, if a check arrives in the amount of $1,000 or less, the court can pass an order authorizing the interested person to endorse the check and deposit that check into that interested person's account to distribute the funds consistent with the order. Plain English, you have closed out an estate, a $900 check comes in. Instead of going through the entire process of opening up an estate, we can ask the court for an order authorizing you to sign the check and put it into your own account. Another law that was recently passed regards wills, and this can be very important as well. Under this new law, a person who has custody of a will has a duty to maintain it. If you're holding the original will of somebody other than your own, you may not destroy it, you may not throw it out, you cannot disclose its contents to anybody else, and you're only allowed to deliver the will while the testator is alive to the person who signed the will, the testator. Next slide, please. Okay. So the custodian of the will or the testator may deliver the will to the register of wills in the county and where he or she resides. Also, if you're the custodian of a will, you must deliver the will upon demand to the testator, that is the person who signed the will, or to somebody who is acting pursuant to a power of attorney signed by the person who signed the will. And here's the key: upon the death of the testator, the custodian must deliver the will to the register of wills in the county in which the testator resided. Now, what I noticed, though, is that in this new law, there's no time frame where it has to be done within 5 days or 5 months or 5 years. So I'm not quite sure exactly how useful the new law is, but that's how the law reads. But what I find more interesting is not so much these new laws, because maybe they apply 1 in every 100 cases. What I find interesting are cases that have occurred here in Maryland or other states regarding trusts and wills and disputes. If there's one thing I love, it's a good dispute. So there's about 7 or 8 cases that have happened over the last year or so, which I think are very interesting. The first one is called Potter versus Potter. And the reason that I'm listing this one is because it happened right here in Anne Arundel County. In this case, Potter owned an interest in an LLC, a limited liability company. All the interest owners of the LLC signed an agreement that basically says that upon the death of one of the owners of the interests, the agreement dictated to whom that interest will pass, and it happens immediately. Well, what happened is Mr. Potter died, and a dispute arose between the interest owners and the beneficiaries of his estate. The issue was, does an interest in a limited liability company pass pursuant to an agreement that was signed by all of the interest owners or to the person's estate? Well, the family members, of course, wanted that asset to pass to the estate. The interest owners were ready to quickly get their hold on the interest of the person who died. What the court held was that an LLC interest is an interest in property, and it is subject to Maryland probate. What that means then is if you have an agreement between limited liability company owners, or I would assume stockholders even, that says to whom the assets will pass, there has to be some mechanism that that connects it to a living trust or to a will, because those assets will have to pass according to the person's estate, unless the LLC agreement was signed with the same attestation, that is the same witness requirements as a will. The bottom line, though, is if you own an interest in a corporation or an LLC, and you have agreements with the other LLC owners or the other stockholders as to what will happen to your interest upon your death, it's really critical to have an appropriate buy-sell agreement by an attorney that also coordinates the passing of those interests to your estate. Maybe the buy-sell agreement might be funded by life insurance, but you do have to make sure that it's coordinated with the testator's or the owner's estate plan. So we go to the next case. Here's a case out of Kansas. Husband and wife created an irrevocable trust. Now, an irrevocable trust is the kind of trust that legally cannot be changed, cannot be revoked, it cannot be amended. Or what I tell my clients is, once you have an irrevocable trust, assume that you're stuck with it forever. So what happened was that this irrevocable trust provided during the husband's lifetime for benefits from the trust to be paid to him. And upon the husband's death, those assets were to pass then to or for the benefit of the children and the grandchildren of the husband and wife. The purpose of this irrevocable trust was to make sure that assets that were in this irrevocable trust passed outside of the wife's estate, because she had a lot of assets and she was trying to move assets out of her estate for estate tax purpose. In fact, the trust agreement specifically said that no part of this trust estate will be included in the grantor's, that was the wife's, gross estate for death tax purposes. So what happened? What happened was the husband and wife went to an attorney who was not named Steve Elville or Gary Greenwald. What happened was the attorney inadvertently forgot to put in a provision into this irrevocable trust that ensured that Jill's intent that the assets stay in this trust, so the assets would not be in the wife's estate, in Jill's estate, for estate tax purposes. And once the trust was done, the wife read it and realized that that petition, that provision was not in her trust. Because the trust was irrevocable, she was concerned that maybe she was stuck with this. But what she did was she went to the court and she petitioned the court, and she asked the court to reform the trust. A reformation of a trust basically means that you ask the court to pass an order which by a judicial proclamation changes the terms of the trust. The question is, can that be done? The answer is, the court ruled yes, it could be. The rule is that if you can prove by clear and convincing evidence of a mistake made in a trust, a court can actually reform or change the terms of a trust. Now, I will say this, that I have been involved in the petition to a court to change the terms of an irrevocable trust, which, just for the record, I did not prepare. And what happened was the trust was done again to try and reduce the value of assets in the person's estate, and a mistake was made in the trust. And what happened was that there were 5 living children, 15 living grandchildren. And in order to go to court, it's not that simple of a thing. You actually have to add as defendants, not only the trustee, well, the trustee is actually filing the petition, you have to add as defendants every single living beneficiary who could possibly inherit from the trust. So I actually had to sue about 17 different people to change this trust. Now, what happened was I spoke to them ahead of time. I told them this is a change that can be made, which will help everybody. So I got everybody's consent, but it still cost about $5,000 or $6,000 in attorney's fees to change the terms of this trust to which everybody agreed. The way to avoid this is having in a trust agreement something called a trust protector. Steve mentioned this earlier. A trust protector is a person that can be appointed either by the then serving trustees or by the beneficiaries of a trust and given the ability to change the terms of a trust in order to correct any inadvertent mistakes that were made in it. Have this person had a trust protector provision in the trust, they could have saved the client, and honestly, most likely the attorney, thousands of dollars in attorney's fees from correcting the trust. Let's go to the next case. DePrins versus Michaels. This is a case out of Massachusetts. You'll like this case. A guy named Bellinger got into a dispute with his neighbors over water rights. Now you would figure if there's a dispute about water rights, it would happen out west because they're running out of water out there. But this is a case out of Massachusetts. Bellinger got into a dispute with his neighbors about water rights. A lawsuit was filed. Basically what Bellinger did after he realized he was going to lose the lawsuit is he put all of his assets into an irrevocable trust. Again, a trust that cannot be changed, where he was the sole beneficiary. And when he died, his daughter would become the sole death beneficiary. And in this trust, spendthrift provisions were put in. And basically, a spendthrift provision is a provision you can put in a trust which says that the trust cannot be changed or amended, and the creditors of the beneficiary do not have any rights to attach the assets in that trust. So basically what he did, he tried to put all of his assets into a trust to avoid what he knew was an impending lawsuit. Well, then shortly after he funded the trust, he killed his neighbor and he killed himself. All right, so pretty an unusual case. Then what happened was the beneficiaries or the heirs of the neighbor filed a suit to set aside the trust. This comes down to something in the law that lawyers call a fraudulent conveyance. The question is, can you put assets into an irrevocable trust in which you are the sole beneficiary, in which you get the only benefits out of it to avoid creditors? The court rightly held no. The court basically said that you cannot put property into a trust for your own benefit to avoid the reach of creditors. So there's a lesson to be learned. If you think you're going to get sued, if you start putting assets into a trust that cannot be attached, or even if you transfer assets to somebody other than yourself, a child, to avoid creditors, that can be set aside as a fraudulent conveyance. And just in case any of you out there are thinking about this, I will tell you that any attorney who's involved in committing the same fraudulent conveyance can also be held responsible. So if you're thinking in terms of doing that, please don't ask me or Steve to help you. We won't do it. Next case is a case out of Texas called Ron versus Ron. Here's a case where the wife creates a trust for the benefit of her children. Husband was appointed as the trustee and a friend was appointed as the trust protector. So in this case, the lawyer thought about putting a trust protector in, and that's exactly what happened. Now, the job of the trust protector was to direct the trustee, to assist the trustee regarding matters of the trust and to achieve the wife's objectives. It permitted the trust protector to add the husband as a beneficiary. So again, this is the wife's trust. The trustee is the husband. It allows the trust protector to add the trust, to add the husband as a beneficiary. You see where this case is going. So when I read the case myself and I saw that the trust protector could add the husband as a beneficiary, in my own notes, I wrote the words, uh-oh, and that's exactly what happened. Husband and wife separated. Wife now files a lawsuit claiming that the husband transferred joint property into the trust before the divorce and that the trust protector wrongfully added the husband as a beneficiary. What happened, believe it or not, the court lost. I mean, the husband lost. The wife lost. The wife tried to set it aside, didn't do it. Because in Texas, the trust protector's job is to assist the trustee and not the beneficiary. So since it was the trust protector who helped the husband get him appointed as a beneficiary, it wasn't the job to protect the wife's interest. The wife lost, the husband won. So you've heard the expression, all my exes live in Texas. Well, in this case, the wife's lawyer again messed it up. And in that case, the phrase ought to be all of my ex-lawyers live in Texas. So we now have had two cases where the clients came to the lawyers didn't quite know what they were doing. It really illustrates the importance of going to an attorney when it comes to trust and estates that know what they're doing. Okay, next case is out of New Hampshire called Hodges versus Johnson. Hodges created two irrevocable trusts with a guy named, I think he pronounced it Satterley and Johnson, who were the trustees. The trusts were created for the benefit of Hodges' children and stepchildren. Hodges hired an attorney to create trusts. And then what happened was he decided that he wanted to decant the trust. Now, when you decant a trust, that's the process of terminating one trust and leaving assets to a second trust for the same beneficiaries, but with much more favorable terms. That's what a decanting of a trust does. So basically, in this case, the lawyer who he hired, there were several decantings of the trusts. And basically what happened was the client wanted to take out or disinherit stepchildren. So after a series of decantings, the stepchildren ended up being disinherited. So what happened then was that Hodges died. The stepchildren realized that they were left out because of all these decantings. The issue was, would the decantings be honored or not? What happened was the stepchildren prevailed. The trustees of the trust filed a motion to recover the cost involved in defending these improper decantings. The court held, number one, that the trustees do not have a right to get reimbursed for defending improper decantings. And second, the trustees were actually ending up being held responsible for the attorney's fees of wrongfully defending the decanting. So not only did they not get their attorney's fees awarded, but the stepchildren who were decanted out of the original trust got their attorney's fees awarded from the trustees. Next case is a case out of Pennsylvania. It's called the Passarelli Family Trust, in re the Passarelli Family Trust. In this case, the husband and wife created an irrevocable trust. So notice a lot of these problems are coming out of irrevocable trusts. The intent of the trust was to make sure that the assets stayed in the family after death. You're going to like this one. The trust was funded with several parcels of real estate. The husband and wife had a lot of real estate. As it turned out, the husband had some real estate in the state of Florida that the wife didn't know about. So what the husband did after the trust was created was he then transferred these properties that he didn't tell his wife about when the trust was originally signed. He transferred these properties in Florida into the trust and decided, without telling his wife, to live in one of those properties in Florida with his girlfriend. Well, the wife found out about it, sued for divorce. What happened was, wife tried to set aside the entire trust as a fraudulent conveyance. The wife tried to claim in court in the divorce proceeding that since the husband did not tell the wife about these properties in Florida and did not tell the wife that it was his intent to live with his girlfriend on one of these properties in Florida, the whole trust should be set aside. Guess who won? Husband won. You're saying, why? How could the husband win in a case like this? Well, here's what happened with the Florida court. Pennsylvania law says that when you create an irrevocable trust, you do not have to give an accurate accounting or inventory of assets as of the date the irrevocable trust is signed. So there was no obligation on the husband's part to tell the wife that he had these properties in Florida and to tell the wife that it was his intention to convey these properties to the Florida trust. The intention of the original trust was other than that. Now, Steve, you may have created irrevocable trust, and then after the trusts are actually prepared, sometime later assets are put into the trust. Have you ever had that happen?
Yes.
Well, here's the deal. There's no legal requirement with irrevocable trusts, at least in the state of Pennsylvania, that all the assets that are going to go into the trust are identified at the time the trust is created. So in this case, unhappy ending for the honorable wife, a happy ending for the husband with the girlfriend. Last case I have is a case out of Alabama. In this case, husband and wife created a trust for children and descendants. The trust intent was to distribute assets to or among the issue and what they called out in Alabama, the primary descendants of such issues, lineal descendants. basically any descendant would be a beneficiary of this trust. This trust was signed in 1971. Well, in the year 2016, one of the children of the husband and wife adopted the husband's adult children. Now, we see adoptions all the time of children below the age of 18. It's not that frequently that you see people adopting children who are adults, but it happened in this case. Well, husband and wife died. The child who adopted the adult stepchild also died. So what happened was the surviving siblings sued to exclude the deceased child's adopted adult son from the trust. They argued that an adopted child who was an adult at the time of the adoption was not contemplated as a potential descendant in this case. In other words, when husband and wife created this trust in 1971, there was no way in the world they could have assumed that one of the descendants could have been an adult, I guess their son-in-law, an adult who was adopted after the age of 18. So the twist here in Alabama, the real issue was, what is the definition of a lineal descendant? And what the court ruled in Alabama was a lineal descendant is somebody who is born after the actual trust defined a lineal descendant as somebody born hereafter, either before or after the trust's death, as well as those people now in existence. What happened was in Alabama, the court stated that there was a statute which basically says that adopted children are considered adopted children for inheritance purposes only if they were minors at the time that they were adopted. So the adult adopted lineal descendant was excluded from inheriting. The court said that a trust signed in 1971 by the husband and wife could not have anticipated the adoption of an adult child. The court also took pains to point out that this only really applies in cases where the adopted child is an adult. It would not apply to other adopted children. So those are 7 cases of things that could possibly go wrong in the planning of an estate plan if you either are not clear in what you want to have in the estate plan, or really more significantly, if you go to an attorney who doesn't know how to ask all the follow-up questions in the planning stage. So it makes really good reading, very interesting reading, but thank goodness Stephen or I have never had any of these types of problems. So those are the cases that I found over the last year that I thought were interesting and would be of benefit to anybody who's listening who at one point or another are going to be a trustee.
Gary, thanks for that. And I'm disappointed you didn't have a joke about Sweet Home Alabama. All right.
Well, we ran out of time. I would have thought.
All right. And I do apologize for going long and not giving Gary enough time. And thank you for sticking with us. Jeff, we're going to turn it over to you so we can wrap up and see any final questions and get these prizes issued.
Well, thank you, Steve. And thank you, Gary, for a great presentation. And we do have a question I want to make sure we get answered. So the question goes back to the tax section, I believe. So the question is Maryland one of the 19 DAPT states, DAPT states?
And I'll answer that question by saying no, it isn't, unfortunately. But the number of DAPT states does continue to grow. So it used to be 16. And so we are still going to our friends in Delaware and other places, Nevada, South Dakota, Alaska, for that kind of planning. But you can do some very significant asset protection planning in Maryland through lifetime Q-tips and other things. But that's a great question.
One thing I did forget to mention in that case about the decanting trust, in Maryland, there's no statute that allows you to decant a trust. There are 25 states in the country that allow you to do it. Maryland is not one of them.
Okay. So if you have a final question and you'd like to get it in, now would certainly be your time to do so. And as I mentioned at the beginning, we do have some tickets to give away from our friends at the Annapolis Symphony Orchestra, the Columbia Orchestra, and Bach in Baltimore, which offers First Sunday concerts in Baltimore. And so we did a random number generator. We assigned everybody a number and selected numbers. And so the first ticket, 2 tickets actually, to the Holiday Pops concert at the Annapolis Symphony Orchestra. So I have a voucher here. And I'm actually going to this concert, so I'm very excited for it. So I hope you will be too.
You didn't win the ticket, did you, Jeff?
I did not. I purchased my tickets. So December 17th at 8 o'clock at Maryland Hall in Annapolis. It's a beautiful place, a beautiful venue if you've never been to watch a concert there. The Elville Center for the Creative Arts is actually a major sponsor of the Annapolis Symphony Orchestra. So we are very proud of that relationship. And the winner of that is the number 8, which is Ted and Bridget Wesley. So congratulations.
Congratulations.
And yes, I'll be getting in touch with you, Ted and Bridget, very soon, as that concert is coming up quickly. It says you need to return this certificate pretty soon to get your tickets, but I'm going to work to see if they can send you electronic tickets, and also want to confirm that you're able to use the tickets too. So we'll go from there. So and the second one, yes, congratulations, Ted and Bridget. The second one was number 12, which was Bill Custis. And these are tickets to the Columbia Orchestra. It's a gift certificate for 2 adult Columbia Orchestra concert tickets, a $44 value, and they expire in May 2022. So I'm going to go ahead and send this to you, and you have about 5 or 6 months to use these tickets for any concert of your choosing. So congratulations.
Congratulations, yes.
Lastly, number 37, and it's Miss Gina Beck. So congratulations. And we have 2 tickets to the Brahms Requiem for Bach in Baltimore, their first Sunday concert. And you have a little bit of time for this. This is Sunday, April 24th at 4 p.m. at the Towson United Methodist Church in Towson. So congratulations to Gina. And I believe that's Gary's client. So I'll be getting in touch with you, or I'll have Gary follow up with you with Polly to get this voucher to you. So congratulations to all of you. And so we want to thank you for being a part of the CCP and for being part of our event today. Thank you to Gary and Steve for a great presentation, and want to wish you all, your family and you, happy holiday, Merry Christmas, happy Hanukkah, and all the other holidays in between. So have a wonderful rest of the weekend as well. And we look forward to seeing you all very soon. So have a great day. Any last thoughts, Steve and Gary?
Just thank you, Jeff, for your commitment and for being here on a Saturday and making this happen for us.
Oh, of course, my pleasure.
Happy holidays to everyone. Thank you, Gary. And everyone be safe and happy in the holiday season and the new year.
Thank you.
Bye, everybody. Thanks for joining us.
See you again soon.